So should dangerous drivers be allowed to dodge a ban? Let's talk to lawyer Nick Freeman, dubbed Mr. Loophole, for getting a series of celebs off the hook for motoring offences. Nick, good morning to you.
Good morning, Mike.
This does make a mockery of the whole system, doesn't it?
Well, when Parliament introduced this legislation, the whole purpose behind it was to allow people who commit relatively trivial offences one final opportunity. And it said in very limited circumstances, if there was exceptional hardship and the driver had to establish that there was exceptional hardship, you have one more chance. And that was could be argued once in a 3-year period. Now, what's happened is the legislation has been badly drafted. It's bad law. And what we have is a situation that you refer to where this particular person has 54 points on his licence. And that's come about. And this often happens where people commit several offences, maybe in the same area or in different areas, and they're all sentenced on one occasion before one court. And when that happens, it means he hasn't argued exceptional hardship before. He's arguing it for a plethora of different offences, that the points tally to a massive total. And if there is exceptional hardship, what that means is the court can then exercise a discretion and decide not to disqualify him at all, to disqualify him for a lesser period, or indeed to disqualify him for the 6-month period or even longer.
But these people are dangerous drivers, though, aren't they?
No, they're not dangerous. They're persistent drivers. They might be dangerous. Most of them, in reality, are people who commit speeding offences, and they may not be going particularly fast. They may be travelling at 36 miles an hour regularly on a particular stretch of road. I'm not condoning it. It's wrong to say they're dangerous, because obviously dangerous driving is a specific offence. They're people who are driving persistently, flouting the law. I think it's
persistently ignoring the law.
Correct. And all Parliament's saying is, look, we don't want to take people out of their houses. We don't want to be able to stop them putting food on the table. We don't want to make them become a burden on the state, so we give them one more chance. And there's a very simple solution. What we should do is reflect what Parliament intended and say, look, if you get 12 points, you're off the road unless there's exceptional hardship. And if there's exceptional hardship, you have one bite for one offence in a 3-year period, and that is it, end of. And that would, in my view, reflect what the original intentions of Parliament would be, and that would prevent the ludicrous situations that we have now, where many people are driving throughout the country with a ridiculously high tally of points.
Right. So if I were to clock up 12 points then, Nick, and there's no bus or train that can get me to work on time. I live in Darlington, I work in Middlesbrough. A taxi would cost me a fortune. Should I be allowed to keep my licence?
Well, what you would have to do is you would have to appear before the magistrates. You'd obviously have to evaluate either yourself or through a lawyer whether those particular circumstances could constitute exceptional hardship. And if you thought they could, and I mean, you'd be asked, well, what would happen? How much do you earn? Could you actually afford a taxi? Have you got a friend? Have you got a family member who could take you there? Or alternatively, what you could do is you could try and persuade the court to disqualify you for under a different section. It's section 34 instead of section 35. And what that means is, so if you had 9 points on and you committed another small speeding offence that was worth 3 points, you could try and persuade the magistrate to say, look, it would be incredibly inconvenient. I wouldn't be able to do this, but there wouldn't be exceptional hardship. Could you please disqualify me under section 34, which means they could disqualify you for a week or 2 weeks. And that operates as an alternative to penalty points, which means that you don't reach that threshold of 12 points, which means that you're then not liable for a minimum ban of 6 months. So there are a whole variety of different ways of approaching it. And, of course, that assumes that you're going to be convicted for the offence. Many people who are charged with speeding are, in fact, acquitted.
But, you tell me that it's about really giving people one more chance. But if somebody's got 20, somebody in Middlesbrough's got 20 points, and this bloke in Wolverhampton then's got 54, explain to me. I mean, surely they've abused that.
It's wrong. I completely agree with you, Mike. It's totally wrong. And it's come about because the legislation is badly drafted, and there is an open window for defendants or lawyers, and I include myself in that because the law permits it, to deal with a whole host of offences on one occasion before one court and say these offences amount to, for example, 54 points. He hasn't argued exceptional hardship before. The consequences of a ban will be this. He would lose his job. He would not be able to pay his mortgage. He couldn't pay his school fees. The courts then they're put in a situation, in my view, they should decide, well, okay, but you knew this beforehand. And okay, we would consider saying we're not going to ban you for the first offence, but you're taking the mickey.
So Nick,
and we're going to.
Would you be prepared to defend the bloke in Wolverhampton who's got 54 points?
The answer is yes, I would. I would give him robust advice. Look, everybody is entitled to advice, Mike. It might not be advice they want to hear. I would give him honest, straightforward advice, as I do with every client. And it might be that I would say to him, I think it's extremely unlikely, even if we established exceptional hardship, and your facts do constitute exceptional hardship, but all that means is you're then giving the court a discretion. And if I was sitting in the court, I would say, yes, I have a discretion, but I'm still going to disqualify you for whatever period I deem appropriate. I would never be persuaded not to disqualify someone with 54 points on the licence, because to me, that person has no serious regard to road traffic law, and he deserves to be removed. Okay. He or she deserves to be removed from the road. But having said that, the client may say to me, I hear what you're saying, Mr. Freeman, but I nevertheless want you to go and argue the case, and I'm therefore duty-bound to argue it. And I would do it to the best of my ability.
Lawyer Nick Freeman, thank you. Mr. Loophole. What do you make of that then?